particularly in my district, when you have high rates of unemployment, but a lot of single parent households, whether that be a single man or a single woman, um, who oftentimes are struggling to survive. This very cumbersome bureaucracy creates a barrier for them to be able to get the help that they need, um, and really provide for their children. Look, I've had experience in the child support um, court. It's 10 minutes over a very long period of time. You never leave there satisfied or feeling content that perhaps this issue would be resolved. And oftentimes, going to child support court is a last resort. It's after the custodial parent has tried to, in good faith, negotiate with the other parent about what support should look like. And at that point, you no longer want to continue having to go to court um, for a prolonged period of time. You just kind of want the issue resolved because the issue didn't begin when you walked into that court. The issue oftentimes has been years in the making. And in that time, you have children that are suffering because they're not getting the help that they need. So I think it is time that we really look at and reimagine what that experience looks like for both the custodial and the non-custodial parents, right? Because even those parents that are not the ones that decided to go to court and are being taken to court by the custodial parent, oftentimes don't have a good experience either, and that says a lot about a system that isn't working to serve the needs of the people it's meant to serve.
Good morning, everybody. Welcome to another Justice Talk from Her Justice. A big thank you to Assemblymember Reyes, who spoke so eloquently about some of the challenges of what we call an invisible justice problem of child support. My name is Amy Barish. I'm the Executive Director at Her Justice, and we stand with women living in poverty in New York City by training and mentoring volunteer attorneys to address their individual and systemic legal needs. So today we're really talking about the systemic part of that problem because we're having a policy talk. And last January, our organization renamed our legal department to call it the Department of Law and Policy, to really acknowledge that we were digging in on the policy side of our work. So I am here today with our policy director, Rachel Bronstein. And Rachel, welcome. I wonder if you could talk to us first before we sort of dig into the child support issue. Can you talk to us a little bit about the overall Her Justice policy approach, since this is a new-ish area for Her Justice, and how Her Justice thinks about policy? What matters to us when we think about policy?
Sure. So for 28 years, our organization has served individual women living in poverty. The policy work that we do, the priorities we've identified, are based on the lived experiences of those women living in poverty. We know that our clients must engage for the help they need with the civil justice system, the courts, the government agencies that make up that system. And our policy work is driving at reform to that system so that it produces the most favorable results for our clients and women like them through equitable, empowering, efficient processes. At the core of our policy work is the notion that economic justice shifts power to women like our clients.
Yeah, really well put. And I wonder, I thought one of the points that Assemblymember Reyes made was so important, not only to child support, but generally, that usually by the time somebody goes to court, whatever problem they're trying to address has been going on for a long time. So they're getting to sort of the court as the last resort. They've tried to solve things amicably and find themselves in court. So can you talk about, we have this big policy agenda, which can be found on our website. Why, when we decided to really dig into one issue, to start with one issue, why did we pick child support in particular?
Well, we know that child support is critical for our clients. And we also know, as Assemblymember Reyes points out, that the courts are a last resort for many of our clients. There are many clients who call us who've tried over the years to work out informal arrangements with the other parent of their child. and the arrangement doesn't work, breakdown in the relationship, or because of intimate partner violence in the relationship. And for families living in poverty, they typically have no other choice if they need this critical income source of child support than to go to the courts. And the New York courts are flooded in normal times with child support cases. There are almost 200,000 filings for child support in the New York courts each year, with 60,000 of those cases being filed in the New York City family courts. We know from our years of representing individual clients that the system to resolve those disputes can be complicated itself, and that usually, certainly clients like HerJustice clients have the best chance of success when they have lawyers. And yet more than 90% of people in child support courts have no lawyer. So the barriers are that much greater to getting this critical help that families need. And it is critical help. Child support is an anti-poverty measure for families. It, for many families, can make up more than 50% of the family's income. And this is particularly the case for families living in poverty. HerJustice clients, after working with one of our lawyers or the pro bono lawyers with whom we work, can see an average of a 70% increase in their incomes after they've obtained child support through the courts. So we know this is a critical issue for our clients, who are primarily Black and brown women. More than half of them are foreign born. And in particular, for immigrant clients, child support may be the only source of income if they're ineligible for public benefits or stimulus payments because of their immigration status.
So that really encapsulates what a huge economic opportunity could be there for people if they were able to navigate the system, and if they were able to get the payments that they deserve and that are available to them. On the other hand, a lot of times when we hear, if we hear about child support discussed nationally, which is not that often, but when we do, it has to do with the burdensome sort of back payments owed oftentimes by low-income men, often of color, sometimes people who are leaving incarceration facilities or who otherwise are not able to meet those burdens. So can you help us make sense of those two, that sort of tension? You know, HerJustice is working with women raising kids who really need the support. But what about that argument that the orders are too high and really are a barrier for some low-income men to get ahead with their lives?
Absolutely. And we know that the child support system is broken for many parents. And we agree that this issue of unfair, unaffordable child support debt for non-custodial parents, the parent not raising the child, is a serious problem. We know that many non-custodial parents don't trust the system, don't feel that the system gives them individual justice, and that is often the case. We at HerJustice take cases, we handle cases where there is income for the support of the child. We handle cases where we believe and where we prevail most often to get the income that the family has available to it for the sake of the client, or of our client, leveraging the pro bono partners support who come to our help. Our view is that those serious and real problems for non-custodial parents should enforce into the shadows the equally serious problems for parents raising children and in need of support. We know that single parents raising children are disproportionately mothers, that those mothers are more likely to be living in poverty, that mothers are almost always the parent filing for child support, and that the inefficiencies of the child support system therefore disproportionately impact the parent, the mother filing, who is waiting for that child support. So fair child support is a gender justice issue, in addition to being an anti-poverty issue for children. And we see those issues as being largely invisible to the public. So our work to reform the civil justice system so that it functions efficiently for all parents, so that children get the support they need, also focuses on this issue. And we know there are many aspects of this conversation around reform for the system for the sake of all parents that are just beginning, that need to be enhanced. For example, an important issue that has been raised recently in the New York courts is the issue of racial equity. There was a recent report commissioned by the Chief Judge of the New York courts, authored by Secretary Jeh Johnson, that calls out the need for further inquiry and further transparency around who's using these courts, whose experience matters at the core of this justice issue. And we know this and other issues need more conversation, and that's what we're starting.
Yeah, that's great. And for, a self-interested plug, we have an interview with Jeh Johnson on our website. The secretary was kind enough to talk about his report with us.
Yeah.
So what I'm hearing from you, Rachel, is kind of two things. One is that not all child support cases are the same. So you do have some low-income folks who maybe are not equipped, but that doesn't mean we shouldn't talk about how that drops children into poverty. So we sort of need to come together around that. And then I wonder if you could explain a little bit how, since we're dealing with people living in poverty, those are our clients, that's who predominantly populate the family courts. Where is that money coming from? So if Her Justice takes cases, only where we think there is income that should be available for the child, can you give some example of what that looks like? Because everybody we're talking about, is struggling to make ends meet. But we're still taking cases where we think there is some resource that could be put at the child's disposal. Can you give an example of what that might look like?
Absolutely. We at Her Justice typically take what we view as the more complex, the harder child support cases, the cases where we think that a lawyer will add significant value to the outcome, not the experience for the parent, but also the outcome of the case. So these are cases not necessarily where there is sort of traditional W-2 tax reportable income on the books, which is frankly a calculation by the support magistrate and easier to achieve a fair result, but cases where there may be a cash business that is under disclosing income, or sort of hidden assets tied up in real estate or other assets, that it would be very difficult for someone without a lawyer to pursue in the courts, to really uncover, because the burden is on the parent seeking child support frequently to present the case to the court and say, here's what I think is available to this child for income. So is it a restaurant business? Is it with cash, or is it a restaurant worker with cash tips, right? These are the kinds of cases where we've had a lot of success because we know from our clients' experience, our clients' knowledge of the family circumstances, that there's money that is available for the child. The challenge is proving that in court, and that is often best done with the best outcomes by a lawyer.
Sure, that makes sense. And I would imagine, I know from our own data that we have a large percentage of clients who are victims or survivors of partner violence. I have to imagine that in that context, it only exacerbates the challenge for the custodial mom to try to prove the income on the other side.
That's absolutely right. We have many clients who have tried, as Assemblymember Reyes said, courts are often a last resort. And we have many clients who come to us who say, I've tried for years. I've tried to wait for the support that the other parents said they'd give me, and it hasn't come through, or it's come through once a year and it's not enough. I'm struggling. I can't get the basic necessities to my child and I need help. And often an issue here that makes that informal arrangement all the more challenging is the trust that's missing from an intimate partner violence situation, the financial abuse that many of our clients experience as part of intimate partner violence. And by that, I mean that the power dynamic means our clients often, as a victim of intimate partner violence, don't either know what the family's financial circumstances are, don't have access to bank accounts or income that might have been coming to the family. So that confluence of factors often for our clients brings them to us, and they say to us, I don't trust that this is going to come to me in an informal way. I need to use the courts. And frankly, even in the court process, sometimes we see that a partner who's committed intimate partner violence against our clients utilizes that litigation process, many motions in court, dragging their feet on bringing that documentation I referenced earlier of financial matters, And so delaying the process, delaying the needed support to our client and the children. So we see it play out. And again, this is an area where in our many years of experience in these cases, we see that lawyers can make a real difference, because lawyers can present that picture to the court, the whole picture of not just what's right in front of the support magistrate, but what might otherwise be going on with this family.
Yeah, yeah. So obviously child support, a huge issue. We think sort of an invisible issue to a lot of people because it's so important for equity reasons, financial reasons, et cetera. So talk a little bit about, since Her Justice decided to really dive in on child support as our first big policy issue, what were the various tools that you decided to bring to bear to analyze the child support issue so that we could try to talk about, as Assemblymember Reyes, kind of reinventing the system?
So as we've been talking about, our own experience in the courts gives us plenty of knowledge about areas that need improvement. Our clients themselves, in conversation, in interviews, in working with our attorneys themselves, give us a lot of wisdom about where the experience felt unfair, where the outcome wasn't what they think and the law mandates was deserved. So in talking to our clients, we've also talked to colleagues for many years in the field. We partner with other legal services organizations. And in thinking about child support as a policy reform area, we did a lot of research to understand what's being said about the issue. And in that process, realized what we knew from our court experience, but sort of became crystal clear, which was that there's a lack of research and data on, in particular, the experience of custodial parents in these cases, but in general, on the justice experience of parents in the child support courts. And so we thought about the tools in our toolbox and what might make sense for another way to gain knowledge and wisdom on this issue. And we decided to embark on a court watching project. And court watching is a concept that a tool that is used for court observation to send lay people, in our case, volunteers, to the courts to observe, standing in the shoes of the litigants in the courtroom, and to observe from sort of that average person's viewpoint what that experience is like, to give a sense of how the courts are serving the public. For us, we sent, starting in 2017, about 90 volunteers over a 2-year period into the New York City family courts to observe case appearances in child support cases. And they reported back to us about 800 child support case observations.
And can you explain, Rachel, are family courts public courtrooms like the criminal court? And how does that work when people who are not party to the action, are sitting in the courtroom?
Family courts are public. And yet, for understandable reasons, given the nature of the matters that are coming before the court, they're handled, the court cases are handled with a degree of sensitivity. So we are grateful that the courts facilitated our volunteers going into what are often tiny courtrooms with families, talking about very sensitive matters about poverty and financial circumstances and family health and well-being. So the courts facilitated our work in this area, letting these 90 volunteers go into these spaces.
And so I guess, drum roll, what did you find after sending this huge number of trained volunteers into the family courts for 2 years? What are the high points of the findings?
I mean, in many ways, what our volunteers observed ratified what we already knew. We know that almost all parents in these cases have no lawyer. And in fact, that was, again, to the point of this tool that we employed, much of what we know is from lawyering on these cases, because we act as the lawyers on these cases. And yet, with more than 90% of parents going through these cases without lawyers, we know there's much more to the picture. So it was extremely valuable for us to have observers in courtrooms where there were no lawyers in almost all of the cases. We also found from the observational data something else we largely know, which is that most of the filers, most of the parents initiating the cases are mothers, and most of those responding to the cases are fathers. And then the observations, generally speaking, and I hope folks will check out our report for more detail, but the observations generally fell into sort of two categories. One being operational issues of the courtroom and the courthouses, and the second being the litigants' trust in the system. So as to the first, the sort of operational category of observations, one takeaway from our data collection is that the court appearances we observed lasted slightly more than 11 minutes. And these cases are not heard typically at a particular time. There's something called a time certain in some types of court cases, and some in the family courts in particular, where if you are scheduled to appear in front of the magistrate at 9:30, you are heard at 9:30. Most of the court appearances that we observed, and in general in child support cases, although it's an area where there's some work being done, if I show up as a parent for a 9 o'clock call for my case, I may not be heard until 2:15. So with an 11-minute average length of appearance, that was a pretty important finding.
Yeah, and that goes back again to something Assemblymember Reyes said, so that explains it. So you're telling me that you get called into court, you've probably been trying to negotiate child support for some period of time, it's not working. You get called into court for an entire day, so you have to travel, and of course this is in the before time, so you travel into the physical building, you may have to get childcare for your kids, you take a day off from work because you don't know what time you're going to appear, and then when you do appear, it's for an average of 11 minutes. And the case is probably not over yet because the duration of the case may go on for months.
That's absolutely right. And to just put more context around that from Her Justice's handling of child support cases, on average, our own cases last more than a year. So an 11-minute court appearance, typically these cases are lasting many months, if not a couple of years. And for the case appearances we observed for the Court Watch project, more than half of them, of that case appearance, were adjourned or postponed with little or no progress being made on the case. So nothing really happened. One of the parents was told to come back with financial documentation, or the parent filing the case hadn't been able to serve the other parent with the papers to give them notice of the court action. So there are some sort of threshold issues in these cases that make them difficult to get off the ground. And so you've got 10 or 11-minute appearances once every few months over a year, 2 years, et cetera. And the inefficiency of that is, I think, a burden for both the system and the litigants, right? The courts don't benefit from short appearances with these parents to get very little information. That doesn't benefit the functioning of the system. And it is also certainly a burden for parents, because parents, and we've heard this from many of our clients, take off work, right? And as we said before, a 10-minute appearance, and you might have thought you were going to be heard at 9 o'clock, and now it's 2:15, your whole day is shot. Those parents might have taken or incurred child support or child care costs, rather, right? You have to find someone to watch your child. There's rarely child care in the courts. So the burden is significant on parents for sure. And one of the clients we interviewed, we did 6 in-depth interviews with Her Justice clients for this project to just round out what we hear from many, many clients over the years, and hear more deeply what this experience is like. And one client we interviewed lost her job because she was appearing in court multiple times, warned by the boss, this is not going to work. And after a certain number of times, lost her job. So the impact is huge. So the very financial security that parents are looking for in these cases is threatened in the rest of their lives.
Yeah, so it really sort of highlights this built-in illogic, it seems to me, because you've got, people who, a custodial parent who hasn't been getting support, we have to assume that's why they've come to court, because they need to remedy that problem. So during this whole time, they're not getting the money they need to lift themselves and their kids out of poverty. They go to court, and because for whatever reason, one party, both parties don't have necessary documents, the court can't proceed. It's not their fault they can't proceed. They don't have the information, but when they don't proceed, it means that custodial parent, again, is not getting money. So you've got this long case period of time. Any delay means delay in income for the custodial parent. And to your point, also means just a burden on the system, sort of churning through these cases and not moving forward at all.
Absolutely, absolutely. And you know, to this point about why the delays, we asked our court watchers to tell us if they could, based on their observations, what was the reason for the delay. And there's a lot of confusion among parents litigating these cases. There's a real lack of information when they enter those courthouse doors. It seems to us from our experience and from this project, the data collected, that few are adequately informed about what they need to kick this process off. And that confusion engenders mistrust in the system, and then further leads to inefficiencies for the courts, right? So this is a sort of ripple effect problem. And we see that overall, the efficacy of these proceedings is reduced and rarely results in the goal, which is the most child support that parents can afford.
So you talked about the two buckets of findings, kind of the operational part and the trust in the system part. Were there any findings about ways in which the courts were handling these cases well? Because certainly they have, if they don't have the information, they have to adjourn. But were there other findings about what goes on in that courtroom without an attorney that showed a real effort on the part of the courts?
Absolutely. I mean, we asked our court watchers to tell us about what it felt like from the litigant's perspective in terms of fairness and this point about sort of confusion or information. And you know, our findings show that the magistrates, the individual jurists, they're called support magistrates in child support cases, often do explain technical terms, ask if there are questions, help with language access issues, right? Providing interpreters. The problem is not at the individual magistrate level. The issue is that with the volume of cases, right? In New York City courts, more than 60,000 of these filed in a normal year, the volume is so huge that the inefficiencies are that much more significant. And so in many instances, magistrates were helpful to litigants, telling them what the next steps were. But at the same time, there was a lot of confusion. There's the setting around these cases is complicated. Even if the issues in a particular case are not complicated, the experience of going to court without legal training and sometimes without legal information is confusing. And so we think that while the court showed many strengths in giving information and talking about next steps, that there is certainly room for improvement because, again, 90%, more than 90% of parents are in these cases without an advocate, without a lawyer to do that for them, to explain next steps for them.
Yeah, and we know even, at Her Justice, we're always trying to communicate with litigants, but we recently redid all of our own manuals, for example, to put them in plain English, just meaning that it's an English that non-lawyers can understand, because we as lawyers sometimes forget to talk like normal people. So, you can explain things, but if you're explaining them from inside the system, it's not necessarily transparently clear to people who don't live in the system. So that's something I think a process we've all done. So this is an amazing amount of data that you were able to collect that we didn't otherwise have. Obviously, the data was collected, what I keep calling in the before times, before the pandemic. So when people were going into physical courts and we could observe those courts. Obviously, the courts look really different now. And the system, which was overburdened then, is now dealing with yet a new burden of technology and other things. What do you see as next steps for the advocacy that we can do around the issue of child support, given where we all are with what the courts look like today?
We appreciate how overwhelming and challenging this situation is, right? That the family courts closed when the pandemic started and have been slow to reopen, and especially in the area of child support, very slow to reopen. And I mean reopen in the sense of providing virtual opportunity for parents to file, for parents to appear in these courts. So very, very difficult from a systems perspective because of the digital divide that many have talked about that exists certainly for Her Justice clients and others living in poverty. And yet we think that this shutdown creates an opportunity for change. We think this is exactly the right moment to be thinking, as Assemblymember Reyes said, about reimagining. Let's reimagine how this system could work differently, because many of the inefficiencies and challenges that existed before the pandemic shutdown were just laid bare by this crisis. We are hopeful that this is the beginning of a conversation with the courts, with policymakers, about how a very important service to the public can be improved for all parents and ultimately for children to be better supported. We've talked about how some cases are complex. The cases that Her Justice handles are often the hard ones, where a lawyer can have the most benefit for the outcome of the case and the experience of the parent. But there are many cases that are simple. And in the current situation in the courts and before the pandemic, essentially all child support cases went through the same courthouse door. And that doesn't seem quite right to us. We think that there's opportunity to think in a more nuanced way about how the system, the justice system, is treating different cases differently, right? Her Justice can choose how to give a client and her circumstances the right kind of legal help. You need a lawyer, you don't need a lawyer, you need advice, you need information. But that has often not been the case. And again, because of volume, et cetera, but it has often not been the case from a systems perspective, a justice systems perspective for child support. So we think that there is an opportunity now, while things have sort of been on pause, to think about how the system overall, for its own sake, its own efficiency, and service to the public, but for also its users, its parents, its families, who often have to go there for the help that they need, can do it better. Informing litigants before they get to the courthouse, so that there's not a sort of legal crisis of confusion in the court system. Collect more data, share it publicly about the experience in the courts, about the outcomes of these cases, so that we can partner with courts and policymakers and others who are doing advocacy in this area to find solutions. And so that ultimately it's improved for all families.
Yeah, I think the informing the litigants seems such a crucial point, both the fact that there are different types, the child support cases come in different shapes and sizes, and we have sort of one system that treats them all the same, but also to your point that a lot of these adjournments, the court had to adjourn because they didn't have the information they needed, but that seems preventable if the litigants had a conversation before they went to court. And right now, it all, as you said, starts in the same way at that courthouse door. So that seems like a real opportunity to have a conversation so that everybody is prepared when they get to the court, and that's the best use of the court's time.
Absolutely, that's absolutely right. I mean, I think sort of bringing to bear prevention model on some of this, I think could really go far in again, improving the experience for litigants and the system overall.
So is there anything that, any last thing you want to say about what you learned? Because you, Rachel, have done a lot of child support cases. And as you said, Her Justice has handled child support for 28 years. So we felt pretty knowledgeable about child support. But was there anything that really digging in this way, both using national research, talking, doing deep conversations with some clients and doing the court watching, that jumped out at you as sort of new or surprising information?
It's interesting. I mean, as you say, I've myself have handled many child support cases, and proud to have worked at Her Justice and with clients on these issues, and know sort of close up how critical this is for many of our clients and people living in poverty. And yet, taking this big picture view over this several years of doing this work and understanding the way that this issue is discussed in research and academic literature and media, and just seeing how something that we know up close, and all of my colleagues at Her Justice know that this is an issue for women living in poverty, and yet the sort of omission of that lens on a problem that is a problem for many others, as we've said, that we knew it, and yet researching it and studying it really brought it home to me in a way that, I feel more committed than ever to have this conversation and to do this work I think it's a critical time. There's so much conversation right now about childhood poverty, and I think we have an opportunity, and we are ready to seize it.
Thank you so much. Yeah, I similarly, you know, when Assemblymember Reyes said children are suffering,
Mm.
kind of how did we stop somehow the national conversations about child support forget to talk about children?
Yeah.
And many of our clients are the ones raising those children. So I really look forward to having a conversation across the issue of child support that, as you said earlier, looks at equity, an equitable approach for all parents. But at the end of the day, to make sure that children are not living in poverty, that really should be the goal for everybody. So thank you so much for the work. We are so excited at Her Justice about this our first policy report, which is out today, is available on our website. There's also more data than we could fit into the report available on our website. So we hope that you'll check that out at herjustice.org. And we really look forward to more conversations with the courts, with our colleagues, with other experts and academics about child support. You know, a lot of different states deal with child support differently. There's a lot to be learned by looking around. In New York, we always think we do everything best, but we can learn a lot from our colleagues. So please, look at the report, check out the data. Like all Justice Talks, this Justice Talk has been recorded. It's going to be available on our website, and as are all prior Justice Talks. So please tune in for the next one. And if you have issues you'd like us to talk about as part of a Justice Talk, please let us know. We'd be happy to do that. So thanks to everybody for joining us today. And thank you, Rachel, for all your incredible work on this issue.
Thank you.